Let us look at other categories of companies. We've seen that the 4 types of companies as stated in the Act: private liability limited company, public liability limited company, a company limited by guarantee, and state-owned companies. The 4 stated in the Act. So let us look at other categories of companies. Let us look at a holding, sometimes called parent and subsidiary. It's not going to be something new. We've looked at consolidation in accounting, so we know what a parent is and what subsidiary is. But let us look at it in the perspective of a company law. So Section 2 of the Act provides that a subsidiary means in relation to another company, where that other company is referred to as a parent, control the composition of the board of the company. So what they are trying to define here is not a subsidiary. They are defining what a parent is. A parent, right, is a company that controls the composition of the board, right, of the company. So that's basically it, right? Is a company, right? A parent is a company, right? A parent company is a company that controls the composition of the board of another company. 1. 2. A parent is a company where the parent is in a position to exercise more than one half of the maximum number of votes that can be exercised at a meeting of companies. So if a parent is to be a parent, it means that it has more than half of the voting rights or the shares in the company, in the other company called the subsidiary. And the parent holds more than one half of the issued shares of the company. So these 3 define what a parent is, right? Or a subsidiary in relationship to another company called the parent, right? So I'm saying that a parent is a company, can either be a company that controls the composition of the board of the subsidiary, or company that is in a position to exercise more than the half of the maximum number of the votes that can be exercised at the meeting of the company. So if you can exercise more than the half of the votes at the meeting, right, then you are a parent to that company. Or you hold more than one half of the issued shares of that company. So it means if they can ask you what is a subsidiary, is basically the opposite, right? Is a company that is controlled by a parent, right? Or where the parent, that's basically it, right? So the definition of this is basically going to be sort of tricky. They might ask you what is a parent. So you can say the parent is either the company is being is a company that controls the composition of the board, right? Or a company that is in position to exercise more than one half of the maximum number of votes that can be exercised at any meeting, or is a company that holds more than one half of the issued share. So if you can say any of this or all of this, that means you have defined what a company, a parent company is. But you can use the same to define what a subsidiary is. So a subsidiary company is a company where the parent controls. The subsidiary is a company where the parent controls the composition of the board, or is in a position to exercise more than one half of the voting rights, and holds one half of the issued share. So it has to be one of these, one or more of these. Not all of these have to be satisfied. No. So it's that's how you can use this to define and find either a parent or either a subsidiary. So let us look at a dormant company. A dormant company is not a type of company or a form of company, but just a status a company can be in. Right? It means that any of the types of company that we have mentioned above can be in this state. Right? So let us look at what is this state that we are talking about. So according to section 2, subsection 1 of the Act, a dormant company means that a company is dormant during any period in which it has no significant accounting period. So a company is dormant during any period in which it had no significant transaction. So if Mubia Lyonse did not have any significant transaction, then it is said to be dormant. It's just a state. That means public company can be dormant. Private can be, or state-owned can be in a dormant state. So, dormant company is a company that has had no significant accounting transaction during any period. So we're talking about an accounting period. The whole year, you did not have any significant accounting transaction. So what is this significant transaction? I keep on just saying, what is this significant transaction, right? So significant transaction, right, can be defined as any transaction which is required to be recorded in the accounting records of a company. If that transaction is required to be recorded in the accounting records, then that's a significant transaction, a significant accounting transaction. But in the definition of significant accounting transaction, they have excluded the following, right? So any transaction that arises from the issue to a subscriber of shares in the company in respect of the application of incorporation, nor any payment of bank charges, license fees, or any other compliance cost. Those ones are not part of significant accounting transaction. They are not. We're saying first, if we are talking about issue of shares to subscribers, these are people that are buying shares company kamamba kumene. So if ngati company kamba kumene mukupanga issue, the only transaction that has happened is issuing these shares. That one is not a significant accounting transaction. Another thing is any other compliance cost, including license fee. Ngati noyo mchaka chose simatipange trade, simunaipepo chilichonse, you haven't paid any salaries, koma chimene mwapereka the license fee, right? Imene is significant accounting transaction. Muna ndalama imene walipira yokha the bank charges, imene is significant. They have excluded from the definition of significant accounting transaction. But any other transaction that is required to be recorded in the accounting records is a significant accounting transaction. So we're seeing that a dormant company is a company that has had no significant accounting transaction during any period. That's a dormant company. So this dormant company can cease being dormant, right, by just having even one single significant accounting transaction. The moment it has one single accounting transaction, for example, they sell something that's a significant accounting transaction. Right? That's basically it. It means that it has ceased to be a dormant company. So there are at least two ways in which a company may be recorded in the registrar as a dormant company. Because the moment it is dormant, mwenegwa ziwitsa a registrar of company kuti ifeyo chili dormant. So there are only two ways in which the registrar can recognize a company being dormant and record this in its register. Right? The first is basically where a company has been dormant from the time of its formation. Company mwayamba, koma you have not done any significant transaction. Mwangwayamba kumene, kwa before kungwayamba register, palibe chimene munachitako significant accounting transaction, simunapangepo. That one is the first way in which the company can be registered as a what? A significant, rather registered as a dormant company. The other way is basically where a company has been dormant since the end of the previous accounting period and is not required to prepare group accounts for that period. So, njira yoyambira ndiona kuti company mwayiyamba lero, right, 1 January, but chisegulireniwa simunapange any significant accounting transaction as defined earlier, right? Any accounting transaction that is required to be recorded in the what? Accounting records. Simunapangepo. Mwina the only thing that you have done is basically what? Issuing shares to the what? To the initial people, subscribers. But now that one is excluded, right? Is excluded. Comma since incorporation, no other accounting transaction have been what? Done. This is the first way. Then you can what? Tell the company, the registrar to register this as a dormant company. The second one is basically munapanga incorporate, comma you have been trading, you have been trading bobo for years. Then period inake maybe 2020 entire COVID or 2021 entire COVID, right? You did not do any transaction the whole year. No significant transaction as defined earlier, right? Then that one is also another way. First, ndona kuti mukabona kuti company mwangwetsegula, no significant transaction has happened since we banga incorporate. The second thing is you have been trading, you've been an active company, right? But chaka china chake 2020, for other reasons, you have not done any significant transaction for the whole year. That's the second what? A second way in which a company can be registered as a dormant company. So in the second scenario, right, for the company or for the registrar to recognize it as a dormant company, right, because the company already trader gali, right, you have been traded for a while, right, for other reasons you want to declare it as a dormant company. What it has to happen is that the members of the company have to pass a special resolution declaring the company dormant. Muona kuti zinthu zavuta. Ndipo mugwirizane nonse ma members of the company, right? At least 75% should agree to that. We are declaring this company dormant. We are declaring this company dormant. So mukagwirizana kuvomereza yes. The second thing is that the company then gives a notice within 14 days to the registrar after declaration. Mukapanga declare, you have passed the resolution, within 14 days, mukauza registrar kuti tabanga declare our company being dormant. This only happens where we're saying kuti it is what? It was been trading, kumachaka china chake, it is what? Ceasing to trade for whatever reason. Right? People can say, we are in hardship, right? We are in hardship. Let us just declare this company dormant. Right? A company formed for the business of banking or insurance is prohibited from declaring itself as dormant. And I would say, my banks, my insurance, these companies are not allowed by the Companies Act to say, they are dormant. Taganiza no ane kuti dormant ani ndrama za anthu. Right? Why makampani ngati awawa akukanisidwa? Right? They are looked at ngati companies that are to do with public interest. Public interest. Meaning kuti atangoti kuti they are dormant, aise zisokonekera. Anthu anasiya ndrama zawo kumeneko. Right? Insurance zosiyana-siyana. Right? These ones are prohibited from saying that a company is dormant. So, the uniqueness of these companies, like the banks and the insurance, right, is that they deal with the public, right, and the premiums as well. So they deal with public deposits and premiums. For that reason, that's why the Companies Act is saying, please, right, you can never declare yourselves as dormant. Any other company can declare themselves as dormant, but these companies, like banks and insurance, right, are not allowed to be dormant. A dormant company is exempted from the requirement of having its account audited, as well as payment of specific fees. Now, this gives us a picture of why members of a company can choose to declare a company as dormant. Why? It is because mukapanga declare already feti dormant, munaifakiwa zinthu sizikuyenda, right? You know, you will not be required to be audited because my audit require money. That means you are saving money. Two, you are also what? You're also exempted from paying other specific costs, right? It means like you are saving money. So mukona kuti 2020 zinthu sizikuyenda, we're not selling anything. Nothing is happening. For example, my airlines, imagine my airlines oti samaenda, right? Samaenda. You can just declare we are dormant for the meantime. Right? We are dormant. Could you know you should not be required to be audited, because audited financially means that mugena utan kualipira ma auditors, which is money, right? Nenga zinthu sakuyenda muurani mukonongaso drama, not a good thing, and you're also exempted from other specific fees, right? So all these are the reasons why members of a company might choose to pass a special resolution to declare their company dormant. So shareholders may therefore find it useful to declare the company dormant where this prospect on the ground detects so, right? Zinthu zavuta pa ground, right? For example, where their core product can only be sold at a loss, yet better prospects are expected in subsequent years. Mukona kuti your only product panopa is what? Selling at a loss. Lero tizingopanga malosi. Koma mundikhulupirira kuti in future we'll do better. Maybe it's just because of the COVID thing, right? But we'll do better. Airlines, sakugulitsa anthu, they have banned. But you know, akangochosa mabana amene, people will start traveling again, right? You can just declare yourself dormant, right? Because otherwise, if you feel out the product, so the only product that you sell, sizateka sokugulitsa, either mupeze product ina kapena company ngota. Koma ine omwe ndichikhulupirira kuti company ikangodutsa phase iyi, chaka ichi tizazitolera. Company product iyambanso kugulitsidwa. So you can wish to declare yourself as a dormant company. So where a dormant company ceases to be dormant, it must inform the registrar within 14 days from the time it makes any significant transaction. So whenever you're no longer or you cease to be a dormant company, mukuyenera kuwaziwisa a registrar of company. Because without doing so, this is an offense punishable. So whenever you do a significant transaction, make sure that you go and notify the registrar of company within 14 days. Like the way you noticed, you notified the registrar of companies when you were declaring that your company is dormant. Same applies when you're actually saying that your company is no longer dormant. You have to make sure that you also notify the company as well. Now, let us look at foreign companies. right? Foreign companies. Foreign company is just a company that is considered as a company incorporated outside Malawi, but which has a place of business or is carrying on business in Malawi. So, company was incorporated outside Malawi, let's say in the UK, but it is carrying on business in Malawi. That's called a foreign company. For example, if Universal East Africa is operating in Malawi, but was formed in South Africa, that's a foreign company, right? So such a company may be registered as a foreign company in Malawi, and most of the provisions in the Act have equal force against foreign companies, the same as local companies. So it doesn't really matter now kuti company is a foreign company, right? Koma ngati yabwera ku Malawi kunoko has to follow all the provisions of the Companies Act 2013. There's no exception because it is a what? It is a foreign company, right? It is a foreign company. That's basically it. You can talk about Airtel, right? Airtel might be a foreign company because it was basically in the UK, right? And operating now here in Malawi, right? That's basically some of the companies that we're talking about, right? So that's a foreign company. But maybe Airtel cannot really be a foreign company because Airtel Malawi anachopanga register ku Malawi kunoko. Koma Airtel Malawi anachopanga register ku Malawi kunoko as a company, as a subsidiary of the maybe Airtel group. But we're saying that company makauti it has been registered kumene koko. Kunoko izangopanga trade. So I don't really know an example that I can give, but kunoko sinapange register chiliyonse, right? Ikuzangopanga trade ku Malawi kunoko, right? So that one is called a foreign company. But if company inaka kunja, yazafuna kusegula company ina ku Malawi kunoko as a subsidiary, right? That's not a foreign company. Now let us finish up by looking at companies and partnership, right? What are the differences, right? So for us to actually appreciate the differences, let us just have a recap of what a partnership is, right? Under Section 3 of the Partnership Act, partnership has been defined as a relationship which subsists between peoples carrying on business in common interest with a view of profit. So we're saying that it is a what? It is a relationship or an association, right, which exists between a number of people, one or more people, right? Carry on business. The aim of carrying on this business is basically what? Making profit together, right? That's basically a partnership, right? So the maximum number of partners in a partnership cannot exceed 20 people unless the partnership is meant for regulated professions. So it means that other regulated professions are can have other than the maximum of 20 people, right? But the maximum that we know, right, is supposed to be 20 people, right? More than one, that's 20. So partnership is governed by the Partnership Act 1969. So it's not governed by the Companies Act 2013, but it has its own act, which is 1969, right? So this is an incorporated association. It is an incorporated association. What does it mean? There is no legal personnel that is formed when you form a partnership. It means that there's no separation between the partners, which are the owners, and the actual business. So, meaning no separate legal personality is brought into existence on the formation of the partnership. And the business and all its assets remain the properties of the partners. Right? We talked about this as we were actually introducing the chapter, right? So we are repeating that there is no separate legal entity that is existing when you form a partnership. So each partner is an agent of the other and hence can affect the legal rights and obligation of the other. For example, let's look at this partnership, right? AB partnership. AB partnership. So partners to this AB partnership is A and B. So what they're saying is A will act as an agent of B, and B will be acting on behalf of what? A. Meaning kuti B atakalowa mu contract yoti apanga yekha, koma in the name of this partnership, ndekuti automatically A is bound. Orana kuti nesinavomereze. No, because you're saying kuti agents, rather partners are agents of each other. Right? It means whatever this person does is binding to both of them. Whatever this one does is binding to the other person. Right? Because of that reason, right, these people have a fiduciary duty, right? A duty of trust, because A is trusting on B. B is trusting on A. So everyone has to have this fiduciary duty, right? Fiduciary duty of trust, right, on the other person, because everyone is acting as an agent of the other person. So a partnership can be formed by a deed or quite informally, and can be formed by simply writing, oral, or even by conduct. So mukamalomo partnership agreement, you have to have this contract called the partnership deed, right? You can have this partnership deed. This is a contract or an agreement that a company, a partnership is starting, right? So it might have its own terms highlighted on this agreement, like the sharing ratio, right? Contribution ratio, and so on and so forth. But sometimes, by talking to each other, a company, right? And you start trading, right? A partnership, and you start trading. That also qualifies to be a valid partnership, or just by conduct. Business yanwe, right? Automatically, that one is but implied, right? It is implied agreement. So that's basically what you should know about this. So in this deed, right, it will set out the terms of the partnership and the partners in the association. Lastly, let us look at what is now the difference between a partnership and a company. So we'll look at them in sections, right? We'll look at them in sections, right? The first thing is that a company can only come into existence through incorporation. Mugena mpite, mugabange register with the Register of Companies, and you incorporate this. That's the only way. But a partnership can come in form just by writing. That's an agreement, or by word of mouth, or by conduct. All these methods, partnership can exist. Exist company. No. The only way you can form a company is through incorporation. Registrar companies and so on. But partnership, you can either do it informally, word of mouth, by conduct, or in writing. The other difference is separate legal personality. We have looked at this a number of times, that a company has a separate legal entity when it is actually separate legal personality when it actually registers as a company. When a company is registered, it assumes a separate legal personality. While for a partnership, it's not like that, right? There's no separation between the business and the partners, right? And this, right, is actually stated in the classical case of Salomon versus Salomon that we will look at when you look at chapter 4. No need to know it right now, but the concept of separate legal personality has been elaborated in the decided case of Salomon versus Salomon Limited. Another difference is that ownership of property, right, by a company, it is basically the company own its own property, right? Because it is a separate legal entity. Asset ake the ake. See our members ake. No, they are his. Because of this separate legal personality, it can own its own assets. But in a partnership, it's not like that, right? the assets of the partnership my asset and then I'm a partners. Mas. Legal suits. Because of this legal personality that the company assumes, a company can sue or can be sued in its own name. Timatoka isumira Airtel Malawi. Or already analogous ndi my directors kwandika isumira Airtel Malawi. Right? And Airtel Malawi can sue an individual or another company in its own name. Right? But where a partnership, in the case of a partnership, it cannot sue in its own name. Right? It has to be sued in the partner's name. Right? That means if A and B associates, right, was to sue muntu wina wake, a company, right? Mlandu umene ulipo ababa si wa A and B associate, no. Ndi wa A and B, and as individuals, A and B versus they say with Airtel. They cannot say with A and B associates, no, because there's no separate legal personality that this business has. So that's another difference. Right? Another difference is that there is perpetual continuity when it comes to partnership. Now, rather to company. For a company, simango tajifage ma members, member wina aga wamwalira. Member akamwalira, ma shares amango basidwa kwa ndani kwa maojeni, the family of the deceased, right? But otherwise, the company will continue. Komaka partnership, what happens is that when a partner dies or a partner actually decides to no longer be part of this partnership, automatically the partnership has to end. Kaya mulipo atatu has to end. So what it means is that partnership between A plus B plus C. Ngati si wamwalira, si kuti mupeka mashares kwa munthu wina, no. It means that you have to dissolve mugawane chiliyonse. So gawana zanuzo mukampase ndani muna ma deceased awo. Komano ngati mufuna kupitiriza ngati business anthu awiri inuyo, what you do is form another partnership. Automatically you form another partnership. Right? But there's no perpetual succession, or in other words, continuity. And lastly, the most attractive thing is the limited liability. Limited liability only appears for companies, right? Companies have limited liability towards debt of the company, right? We saw they are only limited, it's either by shares or by guarantee, right? If it is by shares, it means that you only have liability to the extent of any unpaid shares, right? For guaranteed, you're only liable for any amount that you actually agreed to pay when the company is winding up, right? But for partnership, partners have unlimited liability. It means that business yalowa mgongole yaikulu atha kupita kwa ma partners kukatenga katundu wa personal. This is machitika with a company. So this is one of the attractive elements of having a limited liability company as opposed to any other form of business. And let us look at disclosures and formalities, right? Companies are required by law to compile certain information and make them available to the public, while partners are not required. So every information, my financial statement, mukapanga maina ukasha kwa registrar. My information ina zimakapezeka kwa registrar. Aliyense can go and see those information. Ukangobeka ndura mutu akaona ma financial statement a company iliyonse imene ili register as a company, right? So you can see una kuti koma pomwe partnership, you're not required to do so. So that's another difference. But mukuona kuti it means kuti you cannot run something that is not transparent. mufuna mukhale zoti muziziwa nokha ngati business, right? Mapeza kuti anthu akuziziwa, right? Because it is required by law to actually disclose certain information. And lastly, transferability of shares. It is easier for shares to be transferred from one person to another, right? While takambakaira partnership, if a person dies, right, what has to happen is that partnership here has to be dissolved and form another company if you want to continue business. And also run. Otherwise, transferability is easy when it comes to a company, right? You can just sell your shares to somebody else or give your shares to somebody else. That's all. While here, you have to dissolve and actually form another partnership. So basically, these are the differences between partnership and a company. So this is the end of the chapter. Thank you.